Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys, with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Hello and welcome into the attorneys. Thank you so much for being with us tonight. We appreciate the time. I got a panel of experts ready to deal with a topic that will affect a whole lot of you, so I hope you stick around. A couple of points to keep in mind. If you'd like to join the conversation, that information is at the bottom of the screen, and also attorneys from Hollis Wright are standing by live right now to speak with you, so the opportunity to get some free legal advice. It's all fair, so you don't have to worry about that, but the opportunity to get some good legal advice while the show is on the air tonight. Leading our conversation, Carter Clay, I got to slow down a little
Tough
bit.
to get that out.
I'm ready to go. Carter Clay, a partner with the firm of Hollis Wright, here to lead our conversation. Good to see you, sir.
Good to see you, David. I hope you're doing well.
Doing well, thank you.
Yes, statistics show right now that there are a little over 10 million individual people that are out there that are on some form of governmental disability right now. And of course, I know as soon as I say that, the knee-jerk response from a lot of the viewers is going to be fraud, waste, and abuse. A lot of people out there taking advantage of our government, taking advantage of the system. They're on disability when they shouldn't be. They need to get back to work. And so we may touch upon that a little bit tonight, but one of the things that I want to say is that the system is designed to weed out individuals who are attempting to make a frivolous claim for disability. And the way in which the system is designed and the process itself sort of disincentivizes people from going through the process. And so we are actually very fortunate. This is one of the few times that we have this happen, but we're very fortunate to have Willie Florence here on the show with us here this evening. And the unique thing about Willie is that currently and for the last several years, Willie has been representing individuals who have been filing or applying for disability claims through the government. But before he started doing this, he actually worked with the Social Security Administration system for many, many years. And so he's seen both sides of it. Right. And so at some point during the show, Willie, I may ask you to kind of touch upon this idea or concept that there are a lot of people out there making frivolous claims and otherwise receiving disability benefits when they should not. But anyway, welcome to the show. Thank you so much for being here.
Thank you for having me.
Yeah, tell us a little bit about what you do on a daily basis in your legal practice.
Basically, I do mostly Social Security disability, basically dealing with people from little children, minor children, and older advanced age people. I enjoy doing it. That's my passion. I've been doing it for over 30 years.
Okay. Now, when we talk about Social Security disability, there are really, I guess, two main components to that. It involves the Social Security Administration, and it's going to involve some type of disability. Is that correct? That's
correct. There are two different types of Social Security disability. One is what they call SSID. Basically, that refers to basically what you worked and actually paid in, and basically it's a requirement that you have at least worked 10 out of the last 20 years, basically have full quarters of coverage. And the second one is supplemental security income, which is referred to in abbreviation form. It's like SSI. Basically, that's supplemental security income for people who are based on need, not what they paid in, not what they worked, but based upon them being disability according to the regulations required on the Social Security.
Now, as you know, Willie, we practice in the personal injury realm at our law firm, and we represent a lot of individuals who are either on Social Security disability or are trying to get on Social Security disability as a result of the injury they sustained. And a lot of times people don't understand that difference. They get Social Security disability benefits confused with supplemental security income, or SSI. Has that been your experience as well?
That's correct, because basically they think that basically Social Security SSI is the same as Social Security disability, but basically the difference between the two is one where you actually worked and paid in, and one that you have not worked and paid in.
Right, and so the critical point there is that if you don't have any kind of work history, if you haven't paid into the Social Security system and you become totally disabled, you're not going to be eligible for Social Security disability benefits.
That's correct,
But
exactly.
Alternatively, if you qualify based on the needs basis, or I guess sort of the means test that they have under the supplemental security income, you may qualify for those types of benefits.
That's correct. And also, what is basically the same, basically Social Security disability, which you paid in, and supplemental security income, the disability requirements are the same. You have to meet certain medical impairments listings to get either one, even though one is where you worked and one you didn't, but the disability requirements are the same.
Let's talk a little bit about what is the process that people will have to go through. And I know it's a fairly long process, but kind of hit the high points and we may break it up a little bit. But if somebody is out there and they believe they're totally disabled and they can no longer get gainful employment or sustain gainful employment, what is the first step in the process that they have to go through?
The first step, they have to file an initial application. They can do that either by phone, 800 number, 1-800-77-21213, or they can do it in person. Basically, that's the initial step. And once you file that initial application, then the process will go on. Basically, there's no certain limit how long this time it goes, varies for different situations.
And the process of the initial application, you're referring to the Social Security disability application?
Correct.
What if they know from the outset that they're not going to be eligible for Social Security disability, or they suspect that they will not and they want to go the supplemental security income route? How do you get that process started?
Well, the process is the same. You have to file an application. You have to file one, and normally what Social Security does, if you have enough quarters of coverage, if you have worked in the system, there you will file for both of them. If you have not worked in the system, then you'll file for only one, which is the SSI supplemental security income.
Okay. And do you go? So you go through the same entity?
Exactly.
And if somebody were out there interested in more information about how to go about applying or the overall process, is there a Social Security Administration website that they could go to get additional information about the process?
Exactly. They could go on the website, the ssa.gov. Basically, they can assist them with that. But basically, the main thing, if the individual feels that they're not able to work, they don't need to wait for 12 months. A lot of people say, I got to wait for a year. No, you need to file immediately. Okay. Because it's the process. Basically, you have to be expected to be disabled for at least 12 consecutive months.
All right, and so I think that's an important point is we've got to define what it means to be totally disabled. And you're saying a lot of people make the mistake of thinking, I've got to be disabled and not have employment for 12 months before I can apply, but that's not correct. The reality is that if they believe or expect to be disabled and out of work for 12 months, they can qualify, and that's what you're saying. They should immediately go ahead and get the ball rolling and apply.
Exactly.
What evidence is needed to prove that you're disabled from the individual standpoint?
Well, the individual needs to make sure that they have if they don't have a primary doctor, they need to be receiving some type of medical treatment.
Right.
They need to have some kind of doctor, whether it's basically their primary doctor or some other doctor, basically going to the emergency room. A lot of people, we have a lot of times they don't even go to the hospital. They think they may not have insurance or whatever the problem is, but the bottom line fact is basically they need to go to the doctor, receive treatment that will reflect the severity of it.
Yeah, it's time for us to take our first break of the evening, so let's step aside. We'll pick up the conversation right after this quick break. As we head to break, a reminder of how you can keep up with the firm, Hollis Wright, on social media. A lot of neat things happening on the firm Facebook page, so search it out. Search Hollis Wright on Facebook and like that page. A great resource of information. Also, just wrapped up a really cool giveaway, so the opportunity to win some neat prizes there as well. Just like them there on Facebook. Stay tuned. We've got more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Learning all about disability law, or at least what we can get into in about a half hour. Welcome back into the Attorneys. A reminder, attorneys from Hollis Wright standing by even as we speak just to talk to you. So the number you see there on the screen, if you'll pick that up and give them a call, the opportunity tonight while the show is on the air to speak with attorneys from Hollis Wright. Carter?
Willie, before the break, we had started talking about the initial application process to begin the process of trying to get Social Security disability benefits. And when somebody makes that initial application, what are the chances that they're going to be approved based on that initial application?
Well, the chance of whether or not they're going to be approved has a lot to do with whether or not they have substantial medical evidence to support their claim of disability. And usually 9 out of 10, they don't have the medical support to support their claim for disability. As a result, it being denied. But don't give up at that point. They can file an appeal.
Now, in terms of filling out the paperwork and applying, is it just a matter of filling out 1 or 2 pages, and do you have the ability to provide medical records and letters from doctors as part of the package? What can you do in that regard?
Well, basically, you'll have an application base. You'll have a little light booklet, maybe about several pages, asking you about your doctor's visit. Have you had these different type of tests? It's soliciting the information, and basically, once you submit it to what they call the state disability examiner, they're the one actually review the case and see whether or not they meet certain criteria.
Now, you mentioned a minute ago that about 9 out of 10 times the initial application gets denied.
Yes.
So what is the next step in the process? Is it a matter of appealing that initial denial, or should you wait a period of time and refile? What do you recommend in that regard?
After you officially denied, get your denial notice from the Social Security Administration. Then you have 60 days to file an appeal. They allow 5 days worth of mailing time in that process. So basically, if you get denied Social Security disability the first time, you need to file either, you can do 1 or 2. You can file a request for reconsideration, or you can file a hearing before the administrative law judge. But it's dependent upon, which one you do. I prefer to basically do the administrative law judge level, because that way you get a chance to argue your case before the judge and get someone to represent you.
And state again, what is the alternative route to the administrative law judge?
It's a reconsideration, and it'll be reviewed by someone else that did not review the initial decision.
Okay.
A question we've got here, who determines whether I qualify for disability? Who makes that determination?
The state disability examiner.
Okay.
And then they handle all the disability claims. And then they make their recommendation to the Social Security Administration, and that's where they either approve it or deny it, and that's where it goes.
Okay.
So, I was going to say, talk a little bit about the hearing itself in front of an administrative law judge. Obviously, you're there with the client, correct?
Correct.
And is this held in a courtroom? Is it held in a conference room, by telephone? How is it structured?
It varies. They have what they call video conferences, which basically, to me personally, is not the best interest of the client. I usually object for personal reasons. Based, I like to see who I'm talking to, and basically get the feel like to make more personal. But the administrative law judge will be in the hearing. Basically, be the judge. He'll be sitting up on the bench, and then basically you'll have a stenographer, somebody that be typing up everything the client is saying. Then you have a vocational expert, and his job is determined based upon your last 15 years, what kind of work you can do, what kind of work you've done in the past. Do you have any transferable skills to do other work in the national economy? And usually, basically, the judge would ask him a hypothetical, basically saying, do you feel this person can work based on this hypothetical? He can say he believes he has some transferable skills, or he does not believe he has some transferable skills.
Okay. And you mentioned the vocational expert.
Yes.
Explain a little bit about a vocational expert, vocational rehabilitation individuals, their line of work, and what they do exactly.
These vocational experts have a contract through Social Security Administration, but they state that they are biased. They have no personal opinion. They basically go on the facts of the case, each case. And what happened was the vocational expert, he looks at in his grid and see basically in the vocational lining jobs, different jobs in that different areas. Basically, they say basically they do an evaluation on whether or not this person have any transferable skills.
Now, is this somebody that the Social Security hires and pays for, or are there times where you might hire your own vocational expert?
That's a very good question. Social Security hires they contract with the vocational expert, so the lawyer or your representative, they don't get a chance to hire their vocational expert.
Okay, let's talk a little bit about doctors for a minute. How do you typically present the evidence or testimony from the doctors that are treating your clients in terms of providing favorable testimony from a medical professional about the individual's disability?
Basically, what will happen is prior to the hearing, you have to submit the medical evidence of the treating physician, basically the medical records or from the hospital records, and then the judge would have an opportunity to have reviewed that medical evidence prior to the hearing.
Now, is there an attorney on the other side for the government or the Social Security Administration that can cross-examine your client, or how does that work?
No, it's a non-adversarial proceedings. It's basically like informal. Basically, it's informal, basically, and the judge will allow the representative, the attorney, basically to state his theory of the case, why he feels this client is disabled, that kind of thing. And then the client would testify on the oath that they're telling the truth, and the judge will ask some questions. Then the lawyer will cross-examine. At same that will apply to the vocational expert will be cross-examined by the representative attorney.
And how long does the hearing typically last?
Well, it depends upon the judge. Each judge is different and unique. Some of them go like 30 minutes, some go 20, some go an hour. It all depends.
Let's step aside, take our final break of the evening. An interesting conversation we're having here. Would love to have you be a part of the conversation. Just a few minutes remaining in our program, so go ahead and get those questions into us. Also, here's how you can find the firm on Facebook as well as Twitter. Hollis Wright active on social media. Would love to have you join the community there as well. Stay tuned. We've got more of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright. Now, serving on a jury can be confusing because there's some information that the attorneys in the case aren't allowed to tell you. And in wrongful death cases, it might surprise you. In tonight's Legal 4-in-1, we're answering the question, what evidence is allowed in a wrongful death case? That's a case where one person's conduct caused the death of another. A wrongful death case is a civil cause of action for someone's death where money damages may be awarded, not jail time. In these cases, a lawyer can only talk about punishing and deterring the defendant for causing the death. That leaves out a lot of information about the person who died, including how that person's death has affected his family and his community. The reason lawyers only talk about punishing and deterring the defendant in these cases is this. In a death case, at the end of the trial, the judge will read a jury charge which says the following. The damages in this case are punitive and not compensatory. Punitive damages are awarded to preserve human life, to punish the defendant for its wrongful conduct, and to deter or discourage the defendant and others from doing the same or similar wrongs in the future. This means that in Alabama, lawyers cannot talk about how great the loss was to a person's family or friends for that death. They can't talk about lost wages or the financial impact on that person's family. Lawyers can't mention how much that person loved his wife, kids or grandkids, or what it would have meant to walk a daughter down the aisle, for example, in her wedding. In short, lawyers cannot talk about all the things that a person who died at the hands of another missed out on in his own life. In Alabama, the legislature said you can't put a value of someone's life. So as lawyers, what we can do, the only thing we can do, is ask that the defendant is deterred and punished for the wrongful conduct that caused the death in the first place. We can ask that the jury send a message, a loud message, to prevent such types of death in the future. For example, if a truck driver caused a crash where someone died, the jury can send a message by making the truck driver pay money damages. The hope is that other drivers will be discouraged from the dangerous conduct that caused the death. As attorneys, we often wish we could submit more evidence to the court about the person who died, but unfortunately, we can't. If you are ever a juror on such a case, please keep in mind what I've told you today about wrongful death cases. Remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. A competent lawyer will respond to every question you send in. That's our pledge and promise to you.
Welcome back into the attorneys. This is our final segment, so just a few minutes remaining, about 7-8 minutes remaining in the program. So if you want to join the conversation, take advantage of the opportunity. And also attorneys from Hollis Wright standing by. So if you've got a question for them, now's the time to take advantage, pick up the phone, give them a call, and take advantage of that. Carter?
Yeah, Willie, before the break, we were talking about the actual hearing itself, and you explained kind of that process and how long the hearing typically takes. But from the time of the initial application, how long does an individual typically have to wait before they get their day in court, so to speak, or their hearing before an administrative law judge?
I would say at least about anywhere from 18 to 24 months. It may be a little bit longer because the current, so you have a backlog, so they got a mandate to try to clear up those older cases before they clear up the new cases. And so basically, I say you average look anywhere from 18 to 24 months. But the key in that waiting period, make sure you're receiving treatment from your doctor or the emergency room and your condition. Keep busy going to the doctor.
Now, if you go before the judge and have the hearing and ultimately you get approved and you're going to get disability benefits on a go-forward basis, do you get retroactive or back pay benefits as well?
It all depends. It depends upon whether or not the date that the person is alleging is the date that the judge go with. Sometimes they do an amended decision, which can be subsequent later on down the road, but everybody doesn't automatically get guaranteed to get back benefits.
And are there any other benefits associated with being on Social Security disability, like, for instance, Medicare?
Yes, if you are been disabled at least 24 consecutive months, then basically you can qualify for Medicare.
And do you have to wait a certain period of time after you're approved for benefits before you're eligible for the Medicare portion of that?
That's correct. Unless your retroactive is like 24 months back, and then you're going to immediately be eligible for Medicare.
And how about with respect to SSI or supplemental security income? Is there a corresponding state health like Medicaid that you're eligible for under that scenario?
Yes. If a person is approved for SSI, supplemental security income, then they're automatically eligible for Medicaid through the state.
Question we've got here, if approved for disability, how long do you have to wait before the benefits begin?
It could vary, depends upon the judge. Some judges adjudicate cases faster than other judges, but they have a ballpark figure where somewhere anywhere from 90 to 120 days. Some of them may do a bench decision, where they do it actually on the record. And so that's after if they do a bench decision base, you might receive within 30 days.
Do you deal with situations where during the 18 to 24 months or even after an individual is awarded Social Security disability benefits where they're working part-time, maybe they can't work full-time, but they're able to do a little bit here and there? If you're working in any capacity, is that an automatic disqualifier for you to be on Social Security disability? And if not, what kind of recommendations would you give to the viewers in that regard?
Well, basically, there is a current limit that you're allowed to make. And basically for 2015, the limit has changed. It gradually increased to $1,130. But the thing is, you can't be disabled and able at the same point. I would suggest that basically if you're not able to work, you're not trying, because you can make your disability worse, and then you're going to affect your Social Security.
And we've had situations before, I've seen this, where a person comes to somebody like you and says that they're totally disabled and they can't work, but at the same time they're filing for unemployment.
That's correct.
There's a problem with that, isn't there?
There is a problem.
All right, what's the problem?
The problem is you're telling one agency that you are able to work, and you're telling another agency, the federal government, that you cannot work. And some judges look at that as a big problem, and some of them say, okay, if you receive unemployment, and you stop working, basically, a lot of times people receive unemployment because they have no other income coming in.
Right.
So some judges will award basically after they have received their last unemployment check, they make them disabled at that point.
And this is an important point too that I want to make that we haven't touched upon. If somebody is on supplemental security income or SSI and they've been on it, say, for several years, and for whatever reason, let's say they inherit $100,000 from a deceased relative, can the inheritance or coming into money from an external source or some other source, can that affect your SSI payments?
Yes, that's very true. Basically, if you receive a certain amount over the limit is allowed for an individual, so much money in the bank, basically kind of changed, but basically been stationary. But if you receive an inheritance or a big, somebody give you a big house or something other than one that you have on file, you need to report it.
Okay. Talk a little bit about briefly, what are they doing, and do you think they're better in terms of monitoring and getting rid of the frivolous claims?
I think they're doing a lot better because basically they have what they call a improvement. In other words, trial work period to see if they can work. They're going on the test, and if they can, fine. If they can't, then basically just give them a chance, what they call a trial work period.
And David, I think one thing that we've heard tonight is there are multiple steps and layers that you have to go through. 9 out of 10 are initially denied. So then you've got to go to the next step. Then you got to wait 18 to 24 months before you can even get your hearing, not even knowing whether or not you're going to be awarded disability benefits. So you'd have to really want to be on disability and really be intent on filing a frivolous claim to wait that extended period of time to try and get those benefits.
Yeah, we have just over 2 minutes remaining, and I want to give both of you the opportunity just for a final thought for our viewers tonight. And Mr. Willie, if you would, you go first, please.
Well, my final thought is this: for anyone that's applying for Social Security disability, I think it's imperative that they get someone, I prefer myself, but if you get someone else to represent them, because they don't want to go alone, because it's just too much paperwork, there's a lot of involvement, and the judge enjoys when basically a lawyer comes and he's prepared the case. That helps him to be able to adjudicate the case a lot faster.
Yeah, and I would say record keeping and following up with doctor's visits, making sure that you're complying with what the doctor is telling you to do, making sure that you're not doing anything that you shouldn't be doing in terms of physical activity. There have been times in the past where somebody's, they get involved in an accident and they don't get the treatment that they were supposed to get, or they don't follow up with the doctor when they're supposed to follow up with them and they're not complying. Those are the types of things that I think Willie would tell you that an administrative law judge is going to look at and perhaps rule against you if he finds that you weren't doing your level best to get the treatment that you needed to get back into the workforce. So I would just encourage everybody to keep good documentation, go see the doctors when you're supposed to, and follow the doctor's orders.
Yeah, it's always good to have that paper trail, isn't it?
Yes.
Yeah, get it in writing whenever you can. Mr. Willie, thank you for the time.
Thank you for having me.
Yeah, appreciate it. Interesting conversation. Thank you both for being with us tonight, and thank you, as always, for joining us here on The Attorneys. Hopefully this topic of conversation tonight has been helpful to you. If just now you're thinking of a conversation or a question, you can still get in touch with the firm. They're open 24 hours a day online at hollis-wright.com, a resource for you there to answer a whole lot of your questions, and go ahead and get those conversations and those questions into them. Thanks so much. We'll see you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.